Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Baba Sankar. Professional Ethics class. Friends, on so many occasions during the classes, I told you that there should be the aspect of fellowship between the advocates. We are all brethren. There should be cordial relationship between the bar and bench. And especially, you have to foster respect to your female junior or senior advocates. Here, a senior advocate slapped a junior female advocate, basing on which a case of attempt to rape or outraging modesty, 354 previously, presently section is different. It was framed against him. I advise all of you not to go to that extent. If at all any disputes are there is a bar association, try to get it solved through them. Coming to this particular case, on 19/5/2025, of course, she is JSCM, Sushan Sonnet, JFCM of Trivandrum. She gave bail to an advocate by name Beylin Das. Beylin, Beylin Das. The case is a bail application, Beylin Das versus State of Kerala, represented by SI Vanchiyur PS, BANCHIYOR. It is near by Trivandrum. The crime number is crime number 591 by 2025, registered under different sections like 115 clause 2, 117 clause 1 of the BNS, read with 74. This is the main problem. 74 is a non-bailable offense. Therefore, he has to approach the court for bail after surrendering. Of course, here he was arrested. Better to know what happened. Right. Mr. Beylin Das is a senior advocate, and the informant, we should not tell her name because 74 is there. The informant is working as a junior, and she is a female and working as junior advocate under him. Very recently, she requested the senior advocate to chastise an advocate who misbehaved towards her. ఇవిడు చెప్పింది, సార్ పలానాడు కొంచెం తెంగరాశాలు వేస్తున్నాడు, ఏమీ వార్నింగ్ లేకపోతే తనండి సార్, నా ముందు వాడికి వార్నింగ్ ఇవ్వండి. దిస్ మ్యాన్ హీ డిడ్ నాట్ డూ ఇట్, చెప్పలా. ఒక రోజున the so-called advocate came before this particular woman. When the senior advocate is present, senior advocate గారి సమక్షంలోనే వాడిని చెంపలు వాయించి అవతల పడేసింది. Actually, she warned him, చెంపలు కన్నా she warned him, that man in front of the senior advocate. ఇద్దరు జూనియర్స్ ఆయన కిందే, అందువల్ల ఆయనే మాట్లాడలేదు. ఈ అమ్మాయి మాత్రం సీనియర్ అడ్వకేట్ ప్రజెన్స్లోనే వాడిని నాలుగు దులిపింది. వాడు వెళ్ళిపోయిన తర్వాత అడ్వకేట్ గారి కోపం వచ్చి ఆన్ 13/5/2025 at about 12:30 p.m. the senior advocate, that is Beylin Das, literally assaulted her. కానీ వాడు ఇచ్చిన రిపోర్ట్లో కొంచెం తేడా వచ్చింది. The advocate slapped her right on her left cheek. Number 1. She fell down and got up. Once again, he wrongfully restrained her by holding her right hand and again forcibly slapped her left cheek and thus outraged her modesty. Okay, allegation ఇది. We don't know whether outraging of modesty is there. కింద పడి పైకి లావటం, ఒకవేళ బ్రెస్ట్ పోర్షన్ ఓపెన్ అయిందో లేకుంటే శారీ అనేది ఏదో తెలియదు. ఎనీవే, ద కేస్ ఈస్ result is 74 of the Bharatiya Nyaya Sanhita, which is a non-bailable offense. He was arrested immediately, basing on the complaint of the junior female advocate. He is in the gallows, he is in the jail, he has filed an application for bail. Of course, considering the he was arrested on 16/5. The incident took place on 13/5, and he was arrested on 16/5. After 3 days, he was arrested. Right, he was remanded, and when the bail petition came before the court, APP says no, he should not be given bail. Her statement has to be got recorded under 164 CRPC, presently 183 BNSS. And section 74 of the VNS is non-bailable like that. But basing on the averments of the FIR, and luckily, as no custodial interrogation petition is filed, and of course, the apprehension of the APP that the witnesses can be managed because witnesses are of his office, then the court said, we can set it right by imposing certain conditions. No custodial interrogation petition, of course, is necessary, but it is not. No custodial interrogation petition is necessary, and luckily it is also not filed. So the threatening other things can be set right by imposing certain conditions, and no recovery is necessary. Already scene mahazar has been drafted. There are no previous criminal antecedents to the advocate. Therefore, no useful purpose will be served by keeping him in custody, by keeping him in jail. Ultimately, he was ordered to be released on bail on payment of surety of 50,000 with 2 sureties. He should not enter into 1 CRPS limits for 2 months. He cannot come to the office for 2 months. He has to appear before the investigating officer as and when called for. And he should not at all contact the victim. And no inducement should be made to the witnesses. And if there is any violation, it will lead to a cancellation of the bail. These are the conditions. Normally, you have to understand, మనం ఏమిటి ఇవన్నీ కండిషన్స్ మన ముద్దాలకు పెట్టించేవాళ్ళం మనం. అది లాయర్కే అప్లై అయింది. చాలా బాధాకరమైన పరిస్థితి. సో ఇతను ఆ అమ్మాయిని ఆ పరకంగా చేస్తుంటే డెఫినెట్లీ ఇట్ ఈస్ నాట్ ఎట్ ఆల్ హర్షించదగిన విషయం కాదు. ఇలా చేయకండి అని చెప్పడానికి వీడియో చేశాను. అంతేగాని బెయిల్ అప్లికేషను ఇవన్నీ కామన్. But why? Because both of them are advocates. I am constrained to make this video. Okay? Understand the essence of it and behave in a proper way. Okay? I am stopping here. Thank you very much.